We're here today in State of Ohio versus Javon Rogers, aka Javon Rogers. Case number 25 CR 000096. Defendant is present in open court today with his counsel Chad Mulkey. Your Honor, we're here today on a one-count information that was filed on February 24th of 2025. That one count being theft, a felony of the 5th degree. It's the state's understanding today that the defendant will waive his right to indictment, will plead guilty to the one count in the information. That we will ask to defer sentencing for a pre-sentence report and victim impact statement, and that there's no sentencing agreement. And that's the state's understanding at this time. Thank you.
Thank you. Mr. Mulkey, is that accurate?
All accurate, Your Honor. Thank you.
And Mr. Rogers, were you able to hear what the prosecutor had to say regarding what she believes your intentions are here this morning?
Yes, sir.
She indicated to the court she believes it's your desire to waive your right to have this case presented to a grand jury, and I'm going to explain in a minute what that means.
Yes, sir.
You're then going to plead guilty to the charge and the information which was filed, which I will also go over with you to make sure you understand that.
Yes, sir.
We then defer sentencing to a later day to get some evaluations completed, come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations. Each side is free to recommend to the court whatever sentence they believe would be the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do here today?
Yes, Your Honor.
Well, before I could accept your plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any time you have any questions for me, want me to clarify anything, if you want a moment to speak with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let us know that, because we need to make sure you understand everything going on, all right?
Yes, Your Honor.
All right, let's get started then. How old are you, sir?
33.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes, Your Honor.
Now, before you came into court here this morning, have you had any drugs or alcohol of any kind?
No, sir.
What about within the last 48 hours?
Yes, sir.
What's that?
Marijuana.
When was that?
A few days ago.
Sorry?
A few days ago.
Was it within the last 48 hours? Last 2 days?
Yes, sir. No, not within the last 2 days. I'm sorry. It was a few days ago. I'm sorry.
I don't know what a few days is. So was it, when was it?
The beginning of the week, Monday. I'm sorry.
Okay. So nothing since Wednesday morning?
Monday morning, yes, sir.
Nothing since Wednesday morning then?
Oh, no.
What about prescribed medication? Anything there?
No, sir.
Are you under the influence of marijuana right now?
No, sir.
Or any other drugs or alcohol or medications?
No, Your Honor.
Are you a U.S. citizen?
Yes, sir.
Now, before coming into court here this morning, I should have anyway. Now, did you receive a copy of the information that was filed in this case, the document that sets forth the charge you're accused of committing, what you're going to be admitting to?
Yes, Your Honor.
And you had a chance at some point to look that over?
Yes.
Now, in that information, what's alleged here and what you're admitting to is that, what is your name? Javon Rogers,
Yes,
J-A or J-E?
It's J.A.
J-A-V-O-N, and
Yes, sir.
Rogers with no D?
Right. Yes, Your Honor.
What's alleged here is that on or between September 20th and September 21st of 2024 in Lake County, Ohio, that you did with the purpose to deprive Robin Ansell, A-N-C-E-L-L, the owner of property, being checks, that you knowingly obtained or exerted control over that property without the consent of Robin Ansell, who was the owner, or anyone else authorized to give consent. Further alleged again that the property involved here are printed forms for checks that on their face identify the drawer or maker for whose use they are designed, or identify the account in which they are to be drawn, and they have not been executed by the drawer or maker, or on which the amounts are blank. This conduct constitutes the offense of theft. It's a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 1?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Well, then before I can accept your plea, I need to make sure you understand the rights you are giving up by pleading guilty. And you first of all have a right to have this case presented to a grand jury. So that document that I just read to you, we call it an information. And what an information is, it's actually a charge brought by the prosecutor's office without this case having previously been reviewed or considered by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest the person probably committed a criminal offense. Everyone here in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision whether someone should be charged or not. And you have that right as well, but you can give up that right if you desire and go forward on the charge brought by the prosecutor and the information. And your attorney has indicated he believes that's what you want to do. Is that correct?
Yes, Your Honor.
Well, before I can go any further, I need to have you acknowledge that here in open court in writing. And I have in my possession here a one-page document called a waiver of indictment, which sets forth everything I've just reviewed with you about this grand jury process. Before I can accept your plea, I need to make sure you understand this document and you sign it here in open court. Now, my understanding is before I came out here, you had a chance to go over this document with your lawyer. Is that right?
Yes, Your Honor.
Mr. Mulkey, is that accurate? Did you review this with your client and answer all his questions? And
Yes, Your Honor.
did he indicate an understanding of it to you?
He did.
Is that correct, Mr. Rogers?
Yes. Yes, Your Honor.
Any questions for me about what the document says?
No, Your Honor.
Well, before I can accept your plea, I need to have you sign it here in open court. And I look at it, and it appears that you did sign it. Did you, in fact, sign this?
Yes, Your Honor.
Mr. Mulkey, you witnessed that?
I did.
And you as well, Ms. Cutts?
Yes, Your Honor.
Very well, then I'll make that part of the record. At this point, the court is going to advise you, Mr. Rogers, of all the other rights you have that you're giving up by pleading guilty, and you first of all have a right to a trial. Now, a trial could be to me as a judge, or I listen to all the evidence and I make that decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial, which would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then the jurors would make that ultimate decision. And that ultimate decision reached by the jurors would have to be unanimous, which means all 12 of the jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes, Your Honor.
Now, if we had a trial, the prosecutor here would represent the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation to prove you guilty at a trial before you can ever be found guilty. You're presumed innocent of this charge, and that presumption of innocence will stay with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when I speak of this burden of proof, since it's a criminal case, the burden is what we refer to as proof beyond a reasonable doubt, which is the highest burden we have in our justice system. And what it means, it's the amount of the evidence or the quality of the evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge beyond any reasonable doubt before you could ever be found guilty of the charge. You understand that?
Yes, Your Honor.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
Now, in order to do that, or at least in order to try to do that if we had a trial, the prosecutor would bring witnesses to come into court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and we call that cross-examination. He can ask them anything he wanted to within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand that by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and to answer your lawyer's questions. Now, you don't have to do that, and you're not required to do that, but you have a right to do that if you want to. Do you understand that?
Yes, Your Honor.
Further, I have a right to request this court issue an order that we call a subpoena. which would force or make someone come to court and testify on your behalf and answer your lawyer's questions if that person didn't want to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
You realize you're giving up that right?
Yes, Your Honor.
Now, you also have the right at trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision that you and you alone would have to make. Do you understand that?
Yes, Your Honor.
And since that's solely your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but most importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
Lastly, if we were to go to trial and you were found guilty of this charge, you'd have the right to appeal or challenge that guilty finding to a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
You understand them all?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, sir.
Do you understand that a guilty plea is a complete admission of guilt, which means you're admitting to the facts being alleged by the prosecutor? We're not going to argue you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on a future day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 5th degree. This offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, sir.
Now, you're currently on probation or parole to any other courts or agencies?
I'm on parole, yes, sir.
Post-release control?
Yes, sir.
When was that? When did you get out? When did you get out of prison?
January 5th, 2023.
So it's been over 2 years. How
Yes,
long are you on PRC for?
Actually, she was trying to take me, the day that they arrested me for this case, I was getting off that day. But since I'm fighting this now, she just pushed it back a little longer until this is over with.
Well, I need to advise you that if you commit a new felony while you're on post-release control, the judge who is sentencing you on a new felony, in this case me, has the right at the time of sentencing to terminate your period of post-release control and impose an additional prison term of either 12 months or the amount of time you have left on post-release control, whichever is longer. So if you have less than 12 months left on PRC, then I can impose an additional 12 months in prison. If you have more than that, I can give you whatever you have left. Now, I'm not required to do that, but I have the ability to do that. Even though I may not have been involved with the original case, I can do that. Do you understand that?
Yes, Your Honor.
And if I did do that, any sentence I gave would have to be consecutive to any prison term imposed for the theft. Do you understand that?
Yes, Your Honor.
You know, consecutive means you'd serve the time on the theft first and then serve that additional time afterwards.
Yes, sir.
Do you have any other charges pending against you anywhere?
I think I have a traffic ticket and
Okay, about traffic.
but that's it. No, sir.
No other felonies anywhere?
No, sir.
If a prison term is imposed in this case, upon your release from prison, you could be placed on post-release control for this case. It could be for up to 2 years. Now, it's not mandatory or required. It's up to the parole authority to decide that. It could be up to 2 years. You understand that?
Yes, sir.
And if you are put on post-release control and you're violating any conditions of your supervision, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term is imposed by the court. Do you understand that?
Yes, Your Honor.
Now, aside from the possible prison sentence, there's other sanctions that could be ordered. You could be fined up to $2,500. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, Your Honor.
You could also be ordered to pay restitution if that's applicable to any victim for any economic loss any victim may have suffered as a result of the conduct involved. Do you understand that?
Yes, Your Honor.
Now, a few moments ago, I explained the possible prison sentence you face. I used the word possible because prison is not mandatory in this case. You are eligible for probation, or what we refer to as community control sanctions. Do you understand that?
Yes, Your Honor.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I will consider that if that's what you're asking for. I'll look at all the information that gets presented. Then I'll make the decision I think is the right thing to do. Do you understand that?
Yes, Your Honor.
Now, if you are put on community control, it could be for up to 5 years of supervision. And as a judge, I do have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months, the condition of your probation. You understand that?
Yes, Your Honor.
Further, if you were on probation, this court never violated any of the conditions of your supervision, we would have a hearing to see if you're what we call a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did it at that point, again, it could be 6 to 12 months in prison, and that could be consecutive to any other sentence you may be serving at that time for something else, or that you're being sentenced to at that time. You understand that?
Yes, Your Honor.
Lastly, when we do come back here for sentencing, you're going to have the right at that time to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf. He can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever anyone says at sentencing regarding what they believe the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I don't think it's the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions for me then regarding anything we just talked about, the possible penalties you face by pleading guilty?
No, Your Honor.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to discuss this case with your lawyer and have him review the reports with you, discuss the issues, and answer your questions?
Yes, Your Honor.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Has he or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering this plea freely and voluntarily?
Yes, sir.
All right, then. Do you have any questions for me at this time regarding anything we've just discussed? The rights you're giving up, penalties you face, what you're pleading guilty to, anything at all?
No, Your Honor.
Do you need any more time to speak with your lawyer before we go forward with your actual plea of guilty?
No, Your Honor.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to her and what she says, because I will have some follow-up questions for you about that then, all right?
Yes, sir.
Ms. Cutts?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on September 25th of 2024, Eastlake Police Department responded to 1771 East 337th Street in Eastlake, Lake County, Ohio. Officer met with Robin Ansell, who indicated that on September 20th of 2024, she was moving from an address in Perry Lake County, Ohio on White Oak Court to the current address in Eastlake, Lake County, Ohio. She had paid Armbruster Moving and Storage to move her belongings. They were at her residence helping her move on September 20th and September 21st of 2024. On this date, she had looked at her bank account and found that two of her checks 1307 and 1308, were written out and deposited or cashed. The names on the check for 1307 was Javon Rogers for $1,500, and 1308 was for Alexandria Holt for $800. She instantly recognized Javon Rogers as one of the individuals who had been at her home and was one of the movers. She contacted Armbruster and confirmed that. She also went to her bank, which was Key Bank, regarding her checks. She had not written out those checks. They had been blank when they were taken. She did not authorize anybody to fill them out or to cash or deposit them. She learned that they were both cashed on September 23rd of 2024, and that the 1307 check written to Javon Rogers was cashed at a Chase Bank, and that bank account came back to a Javon Rogers, where the $1,500 was deposited. All of this occurring in Lake County, Ohio, and that would have been the state's evidence.
Mr. Rogers, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we had a trial?
Yes, sir.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Yes, sir.
Very well, then, regarding count one, charging you with theft of felony of the 5th degree, what is your plea at this time?
Guilty.
I have in my possession at this time a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just gone over with you. Before I can accept your plea, I need to make sure you understand this document, that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to look over this document with your lawyer. Is that correct?
Yes, sir.
Mr. Mulkey, is that accurate? Did you review this with your client and go over it with him?
Yes, Your Honor.
Did he indicate an understanding of it to you?
Yes, Your Honor.
Is that correct, Mr. Rogers? You understand the document?
Yes, sir.
Any questions for me about what it says?
No, Your Honor.
Did you sign this document?
Yes, Your Honor.
Mr. Mulkey, did you witness that?
Yes, Your Honor.
Let's cut you as well.
Yes, Your Honor.
Very well, then, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer advised of all his constitutional rights and made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of count 1, theft, the felony of the 5th degree in violation of 2913.02A1. This time the court will defer sentencing, order pre-sentence report and investigation, drug and alcohol evaluation, victim impact statement. Will be continued at this point. $3,500 cash surety or 10% with an order that the defendant have no contact with the victim. He's on GPS too?
Yes.
Why is that?
The Willoughby Municipal Court put him on GPS. I don't know if it was related to being on post-release control, but the Willoughby Municipal Court placed him on GPS.
You paying for that?
Yes, sir.
I'm going to remove the GPS. There's cases where it's appropriate. He didn't know the victim, right? She was
Well,
hired by the victim to
He was at her residence, both of her
Good.
residences, so there was concern about his knowledge of where she lives.
not to have any contact with her, but I don't think it's appropriate. GPS is necessary.
Nice.
But you'd have no contact with the victim. So what all this means at this point, your bond's being continued to comply with the conditions of bond. One of those conditions has been and will continue to be not to use any drugs while you're on bond. You have to submit urine screens. If they come back positive, your bond will be revoked and warrant will be issued. Do you understand that?
Yes, Your Honor.
That includes no marijuana.
I understand that now, yes, sir.
Sorry?
I see it, yes, sir.
Well, why were you using marijuana then?
It wasn't on the Willoughbys. I asked because parole allowed it, so I asked.
Parole allows you?
Yes, sir.
And you asked who?
The Willoughby Municipal Court, what my bond stipulations was, and they said there wasn't any, so I just.
So you thought you could use drugs?
Just marijuana, that's all. Yes, sir. Only
You
because
test
my
po-
parole
you gotta
allowed.
test positive for anything else?
No, sir.
Are you working?
Yes, sir.
Where?
Corrigan's moving system.
Huh?
Corrigan moving system.
Is this the same moving company you were working for when this happened?
No, a different one.
All right, well, I'm referring you for some reports. The purpose of these reports is to learn more about you before sentence is imposed. The way they get the information they need, probation department, to put these reports together is they're going to conduct some interviews with you. It's important that you're open and honest with them because they're going to check and verify everything you tell them. If they learn you're misleading them, they're going to let me know, and I'll consider that as sentencing. You understand that?
Yes, Your Honor.
All right, so you're going to leave here now. You're going to go to the probation department, fill out some initial paperwork, get your dates to come back for the interviews. So make sure you go there when you leave here today,
Yes, sir.
and then also make sure you go back when you're supposed to for those interviews. Because if you don't cooperate with them in that regard, then they can't complete the reports, and without the reports, I can't even consider probation as an option. And if you go over there now, they'll also make the arrangements to get that bracelet off.
Okay, thank you.
All right, is there anything else for the record at this time? Mrs. Hutz?
No, thank you, Your Honor.
Mr. Mulkey?
Your Honor, I'd just like to put on the record that I have explained to him to head immediately over to probation right from this courtroom. Your Honor, normally I like to escort my clients when I'm able to do so. I have another upcoming
Do you know where it is?
case.
Yes, sir.
Okay, third floor. All right.
Thank
All
you,
right,
Judge.
thank
Nothing
Mr.
further.
Mulkey.
All right. present case State of Ohio versus Brandon R. Swope, case number 24CR1386, and the defendant is present today in court represented by attorney Rachel Smith. And we are here for purposes of a change of plea on this case only to count 1, aggravated possession of drugs, a felony of the 5th degree with the forfeiture specification. The state, in terms of the plea negotiations at the time of sentencing, will recommend 11 months in prison on this case. Thank you.
But he's free to recommend whatever he wants.
That is correct. And I will also, on case number 25CR234, I will file a motion to vacate the information to present.
So we were scheduled for a plea on this case and an information plea on that case. What's going on?
Your
We
Honor,
delayed this. We were scheduled for this initially, then we delayed it because he agreed to do an information, I thought.
Your Honor, I am present for Attorney William Watson on behalf of Mr. Swope.
Okay?
Based on the conversations that I have had with Mr. Swope this morning, he did indicate that he had previously agreed to change his plea in both, well, to change his plea in the present matter and to plead to the information in the other. Following our conversations, he has expressed that that is no longer his desire,
So he changed his mind?
and he has changed his mind.
Okay. So then you're going to vacate the information that was filed and take that matter to the grand jury?
Yes, Your
Will
Honor.
that be, how long will that take to get to the grand jury?
I will check with the officer's availability for the next week
Okay.
or two.
Okay, good, thank you. All right, Mr. Swope, in regards to this case, then it's been represented that it's your intention this morning to withdraw your previous entered plea of not guilty to count 1, plead guilty to that count. Count 2 would get dismissed. Sentencing will be scheduled at a later day where the state's indicated they're going to be recommending an 11-month prison term, but you are free to recommend to the court whatever sentence you believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyers and the prosecutor and what you want to do at this time?
Yes, sir.
Well, before I can accept your plea, well, let me ask you this. And then the other case where information was filed, you've changed your mind on that and you don't want to plead guilty to that charge and the information at this point?
Correct.
So you understand that that information will be vacated because it hasn't been presented to the grand jury and it needs to be presented to the grand jury since it's a felony, and they will present and return whatever charges the grand jury determines are appropriate. You understand that?
Yes, sir.
Okay.
Your Honor, for purposes of the record, may I just add that I myself have had that conversation with Mr. Swope, that the charge on the information is not necessarily the charge that will be returned, that may be returned by the grand jury, and he is aware that...
Well, the charge and the information was an attempted, and I'm assuming, like I said, I don't know the facts. Maybe it truly is just an attempt. I don't know. But if it's, I was assuming, I guess, that was part of plea negotiations where the state agreed to do it as an attempt instead of the principal offense. So I'm assuming if it goes to grand jury, they're going to present it as a, was it a theft, right?
Of a motor vehicle.
Right. They're going to present it as a grand theft of a motor vehicle, which would be a felony 4.
Yes.
And I just wanted the record
You
to
understand
be...
that, Mr. Swope?
Yeah.
Okay. I mean, who knows what the grand jury is going to do, but I mean, that they'll be presenting it to them seeking charges of a felony of the 4th degree, and then I don't know if there's other charges or not from the facts. I don't know, but they can present whatever they want to the grand jury, but it sounds like from the prosecutor says that would be what they'll be seeking is a felony of the 4th degree grand theft of a motor vehicle charge. Understand that?
Yeah.
Okay. All right, well then before I can accept your guilty plea to this, the count 1 in this case, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I will ask you a series of questions. If at any point when I'm asking you the questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you need a moment to talk with your lawyer to ask her questions, or even if you want to ask me questions, make sure you let me know that because I need to make sure you understand what's going on, all right?
Okay.
All right. Let's get started then. How old are you, sir?
30 years old.
30?
Correct.
Are you able to read and write the English language?
Yes, I am.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, I do not.
Are you a U.S. citizen?
Yes, I am.
Now, before you came into court here today, have you had any drugs or alcohol of any kind?
No, I have not.
What about in the last 48 hours?
No, I have not.
Not even prescribed medication, nothing?
Yes, I take medications.
What prescribed medication then have you had within the last couple days is what I'm...
Colodidine and Topramate.
Topamine. Do either of those medications affect your ability to understand or appreciate where you are or what's going on? That they negatively impact you in any way in that regard?
No.
Okay. You gotta sneeze. Excuse me.
Not to my awareness.
Have you received, I know you did, or you received a copy of this indictment? It looks like you got it sometime in December of last year. That's the document that sets forth the 2 charges you're accused of committing. Did you get that?
What is it?
The indictment that sets forth the 2 charges, you would have got that right before your arraignment. Sets forth the charge of the drug charge and then count 2 of the assault charge.
It's the piece of paper that lays out the charges.
I'm not sure if I received it or not.
Blue copy, the original copy you would have gotten was probably a blue copy.
No, I never received the blue paper.
And you would have had to get it at arraignment.
Yeah, you were arraigned on the case, right?
Yeah, I was arraigned, but I never got a blue paper.
Did you get a piece of paper that listed your charges and then
Did-
the legal statute that they're under? You would have acknowledged receiving it when you were arraigned. Rachel, do you have a copy of the indictment in your file? I'll give it back. Thanks. So, count 1, that's the allegation. It's the date where, what you're alleged to have done, what the offense is, statute it falls under.
You would have received it on December 23rd at 12:58 p.m.
Are you willing to waive receipt?
Do I what?
Are you willing to waive receipt of the indictment for purposes of this hearing? You know what your charge is, right?
Yeah, I know.
And you're comfortable, that's the purpose of your indictment.
Okay.
Are you willing to waive actually receiving a paper copy of it?
In fact, you signed for it.
Did you hear the judge?
So in fact, you signed for it at 12:58 p.m. on December 23rd.
Okay.
Are you willing to acknowledge
Yeah.
you received a copy of the indictment? That's what he's looking at. Thank you.
Oh, yeah, okay. Then yeah.
All right. Well, that indictment, you're charged with 2 counts. Pleading guilty to count 1, so I'm going to go over that one. All set? I'm going to review count 1 with you here. What's alleged here and what you're admitting to is on or about November 15th, 2024 in Painesville, Lake County, Ohio, that you did knowingly obtain, possess, or use a methamphetamine or some compound mixture, preparation, or substance containing methamphetamine. It's a Schedule II controlled substance. The amount did not equal or exceed the bulk amount, which makes the offense aggravated possession of drugs, a felony of the 5th degree. Do you understand what you're charged with in pleading guilty to in count 1?
Yes, sir.
Any questions for me about that?
No, sir.
Now, there's also a forfeiture specification that's a part of this charge, which alleges during the commission of the offense you possessed or had an interest in property considered to be contraband or an instrumentality. Contraband is property that's illegal just because of by the nature of the property itself, whereas an instrumentality is some type of property that it may not be illegal in and of itself, but it's being used in an illegal manner to facilitate a crime, and you can't possess it for that purpose. And here it's alleged we have the methamphetamine itself as contraband, as well as a syringe and packaging as instrumentalities. The whole point of this specification is that you forfeit any ownership right you have to that property. It doesn't increase any potential penalty that can be imposed, but you forfeit your interest in it. You understand that?
Yes, sir.
Any questions for me about it?
No, sir.
Now, there is a second count of the indictment and a misdemeanor assault charge that's being dismissed pursuant to the agreement. Is that your understanding?
Yes, sir.
Any questions about that charge?
No, sir.
Well, then before I can accept your plea of guilty to the count 1 here, the specification, I need to make sure you understand the rights you are giving up. And you first of all have a right to a trial. Excuse me. And that trial could be to me as a judge, where I listen to the evidence and make that ultimate decision whether you're guilty or not guilty. but you also have a constitutional right to have a jury trial, which would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by the jurors would have to be unanimous, which means all 12 of the jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes, sir.
If we had a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. Having the burden of proof means that it's her job, or she bears the responsibility, the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of the charge, and the presumption of innocence stays with you until the state, if at all, was ever able at a trial to overcome that presumption of innocence and prove you guilty. Do you understand that?
Yes, sir.
Now, when I speak of this burden of proof, since this is a criminal case, the burden is what we refer to as proof beyond a reasonable doubt, which is the highest burden there is in our justice system. And what it actually means, it's the amount of the evidence, the quality of the evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of this charge beyond any reasonable doubt before you could ever be found guilty at a trial of this charge. You understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, sir.
Now, in order to try to do that, if we did have a trial, the prosecutor would bring witnesses to come into court to testify for the state by answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. We call that cross-examination. She could ask them anything she wanted to within certain rules. Do you understand that?
Yes, sir.
If you understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that will come in here and testify against you.
Yes, sir.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have a right to do that if you wanted. Do you understand?
Yes, sir.
And you further can request this court issue an order, and we call that order a subpoena. What a subpoena would do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
Do you realize you're giving up that right?
Yes, sir.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's solely your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But most importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
Further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
You understand them all?
Yes, sir.
You still want to plead guilty?
Yes, sir.
You understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is you'll be found guilty by this court, and then you will subsequently on another date be sentenced by the court. Do you understand that?
Yes, sir.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 5th degree. This offense carries with it a possible term in prison of a minimum of 6 months, maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, sir.
Are you currently on probation or post-release control to any other courts or agencies?
No, I am not.
Okay. I know you have another charge pending, one in this case at least, or in this court I should say, not this case, but this court. Any others?
No.
Okay. At the time of sentencing, it sounds like that other case is still going to be open at that point. It'll still be pending. But if you were sent, I ask this because if you're sent to prison prior to being sentenced, if you're sent to prison on another case prior to being sentenced in this case, I could run my sentence concurrent or consecutive to that. Concurrent means you serve them together at the same time. Consecutive means one after the other. You'd serve that other term, finish it, then serve the sentence in this case. You understand the difference there?
Yes.
Now, I could only do that if there's a sentence that's already been, a prison sentence that's already been imposed. I can't do that to some future possible unknown sentence. So I can't say, I'm going to be just hypothetically 8 months in prison, be served consecutive to the prison term that may get imposed in that case. I can't do that. It's got to already be imposed. You understand that?
Yes, sir.
Okay. Now, if there's another case that comes down after, if you're sent to prison in this case, another case that comes down, that sentence could be served consecutive or concurrent to what gets imposed in this case. You understand that?
Yes, sir.
All right. If a prison sentence is imposed in this case upon your release from prison, you could be placed on what we call post-release control, sometimes referred to as parole. That's a period of supervision you would be on after you served and completed the prison sentence. And in this particular case, it could be up to 2 years. Do you understand that?
Yes, sir.
If you were on post-release control and you're violating any of the conditions of your supervision, the parole authority would return you to prison, or not would, could return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, sir.
Now, aside from this possible prison term I've just mentioned, there's other possible penalties that could be imposed. You could be fined up to $2,500. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any that were applicable in this case. Do you understand that?
Yes, sir.
I could also suspend your driver's license for up to 5 years. Do you understand that?
Yes, sir.
And something else. Oh, the forfeiture spec, as I mentioned before, any right, title, or interest you have in any of that property I mentioned will be forfeited to the state of Ohio. Do you understand that?
Yes, sir.
Now, a few moments ago I explained the possible prison sentence you face. I used the word possible because prison's not mandatory with this charge. You are eligible for probation and what's called community control sanctions. Do you understand that?
Yes, sir.
Do you understand that just because you're eligible doesn't mean you'd automatically be put on probation? It means it would be considered if that's what you were requesting. I'll look at all the information that gets presented, then make the decision that ultimately I thought was the right thing to do. Do you understand that?
Yes, sir.
Now, if you are put on probation, it could be for up to 5 years, and as the judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail up to 6 months, the condition of your probation. Do you understand that?
Yes, sir.
Further, if you ever were put on probation in this court and you violated any of the conditions or rules of your supervision, we'd have a hearing here in court to see if you're what's called a probation violator. And if it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did it at that point, again, it could be 6 to 12 months, and it could be consecutive to any other prison sentence that you may be serving at that time, or that you're being sentenced to at that time. Do you understand that?
Yes, sir.
Lastly, when we do come back here for sentencing, you'll have the right on that day to say anything you want me to know or consider. Your lawyer could speak on your behalf and recommend the sentence to the court. The prosecutor also has a right to recommend the sentence to the court. Do you understand all that?
Yes, sir.
Do you understand that whatever the lawyers say at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to go along and follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, sir.
Excuse me. All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
No, sir.
Do you understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Have you had enough time to talk about this case with your attorneys and have them review everything with you?
Yes, sir.
Have any of them made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering the plea freely and voluntarily?
Yes, I am.
All right, then any questions for me at this time, Mr. Swope, regarding anything we've talked about, what you're pleading to, rights you're giving up, penalties you face? Any questions about anything?
No, I do not. The only, the indictment thing that I got confused about, I thought it was for the motor vehicle. That was why.
No, you never got one in that case.
Right, that was why.
That's what will happen next. In that case, we thought they're going to take the case to grand jury. If the grand jury returns an indictment, then you'll get served with that one, just like you were with
Yeah,
this
that
one.
was why there was a
Okay,
mix-up.
no worries. Any other questions?
Nope.
Then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to her, because I'll have some questions for you about that then, all right?
Yes, sir.
Just with,
Thank you, Your Honor.
just
If-
regarding the drug charge, obviously.
Just, okay. The police, if this case proceeded to trial, the facts would have shown that on November 15th, 2024, in the city of Painesville, Lake County, Ohio, the police responded to a residence at 45 Watson Street. The defendant was placed under arrest. Inside his hoodie pocket, the officers located a syringe that he stated he used to inject heroin approximately an hour ago. Officers also located a small bag in his hoodie that contained methamphetamine, Schedule II controlled substance, in less than 3 grams. Thank you.
Thank you. So, Mr. Swope, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show if we had a trial?
Yes.
And what, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said in regards to count 1?
Yes.
Very well then, regarding count 1, charging with aggravated possession of drugs, the drugs being methamphetamine, a Schedule II controlled substance, along with that forfeiture specification. What is your plea to that at this time?
Guilty.
All right, I have in my possession at this time a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just reviewed with you. Before I can accept your plea, I need to make sure you understand the document that you sign in here in open court. My understanding is before I came out here, you had a chance to go over that with your lawyer. Is that correct?
Correct.
Ms. Smith, is that accurate? Did you review this with Mr. Swope and read it over with him?
That is correct, Your Honor. I did have opportunity to review in detail the written plea of guilty and did witness my client sign that written plea as well as affix my signature to the same.
Is that correct, Mr. Swope?
Yes.
You understand what the document says?
Yes.
Any questions for me about it?
No.
It also appears that you signed it a couple times, actually. Did you in fact sign it a couple times?
Correct.
Ms. Smith, you witnessed those signatures?
I did, Your Honor.
And Ms. Wood, you witnessed at least the second one?
Correct. I witnessed him sign underneath
Okay.
his first signature.
Thank you. Very well, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of count 1, aggravated possession of drugs, a felony of the 5th degree in violation of 29, 25, 11 of the revised code, along with the forfeiture specification. Count 2 will get dismissed as agreed to at time of sentencing. Sentencing will be deferred. Order pre-sentence report investigation and just the pre-sentence report investigation, and bond is continued. Ms. Wood, anything else for the record at this point?
No, Your Honor.
Ms. Smith?
Your Honor, could we add an AOD alcohol and other drugs assessment to the pre-sentence investigations?
Sure.
Thank you.
Can I see counsel at sidebar for 1 second? This is off the record, man. Mr. Swope, what I was discussing with them, when I had a pretrial in this case, and that pretrial was 2 months ago, they indicated that there was a new case being a vandalism charge in the jail. So that's what I thought the second case was. I was just advised that that case was dismissed. You're aware of that, correct?
Correct.
So that I was just trying to clarify in my mind. I was confused when I heard the second case was a theft charge because I thought it was a vandalism charge. But that charge is dismissed, so it's not an issue any longer. That's what I was asking them about.
Okay.
All right. Anything else for the record?
No, Your Honor. Thank you.
Smith?
No, Your Honor.
All right,
So-
thanks.
Present in the case of State of Ohio versus Aretha Fitzgerald, 25 CR44. The defendant is present with counsel, Rachel Smith. We're here today for the purposes of a sentencing hearing. The defendant does have 1 day of jail time credit. Thank you.
Ms. Smith, any reason not to go forward with sentencing?
There's none that I'm aware of, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor, if it pleases the court. Ms. Fitzgerald is before the court today, having accepted responsibility by way of pleading guilty to information and waiving grand jury presentment. She has been on bond for the pendency of this matter without issue and provided 2 drug screens, one on February 3rd, one on February 10th, both of which were negative. Ms. Fitzgerald is 56 years old. She's married, has been married to her current husband for approximately 8 years. She has 4 children, 4 grandchildren. She's a high school graduate, has attended some college, and is a homeowner in the city of Richmond Heights, where she and her husband have lived for 6 years. She is employed as a full-time as a paralegal and has minimal criminal history. Ms. Fitzgerald has 2 prior convictions, both of which were misdemeanors, the first in 1988, the most recent being in 1994, save for this case. Ms. Fitzgerald has no history of drug and alcohol addiction, no known mental health issues, and per the pre-sentence report, it suggests a low risk of recidivism. Based on those factors, Your Honor, we do believe that Ms. Fitzgerald is amenable to community control. We would ask the court to impose a period of community control to allow Ms. Fitzgerald to continue working and to pay both the restitution in this case as well as the interrelated civil judgment that exists, Your Honor.
Thank you. Ms. Fitzgerald, you have the right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
Yes, thank you, Your Honor. First, I would like to express my deepest remorse and regret for my actions towards the estate of Robert Charles Scott, Madeline Wilby, and also Sheriff Thomas Law. I know I have caused, I understand that my actions were unacceptable. I take full responsibility for my actions, and I am committed to making amends for it. I showed a serious lack of judgment in my actions. When I first did it, it was to cover an error that I had made in an account.
Now you need to explain that to me, because for the life of me, I can't figure out how writing $60-some thousand worth of checks payable to you covers an error.
No.
I can't figure it out.
I'm saying when I first did it, it was to cover an error in
Explain that to me.
There was another account that had nothing, that did not have anything to do with this account.
Okay.
The person's check had bounced. I didn't bring it to the attention of Sheriff Thomas like I should have. So, because it was my mistake. And
What was your mistake?
the account of the other case that I messed up.
What'd you do?
The numbers came off. It was like it was more given to someone else, to another entity, as opposed to paying the fiduciary.
Okay.
So when he went to go cash his check bounced. So I covered. So
how does writing a check payable to you cover that?
because I then took the money and put it into his account so it would cover his check. So that's what I did the first time. Now after that, yes, the rest of it, yes, it was used for my benefit.
You didn't admit that at all when you were at the probation department. You said all of this was to cover.
No, I said it was to cover it. I didn't go into the specifics of it. I said it was to cover an account, an error that I made on an account. I didn't go into the specifics of what the error was.
So you were short on one account, so you wrote a check on this account to get the money to put back in that account?
Yes.
Well then, this account that you wrote the check on was going to be short, right?
Yes. It would have been short. And it was my intent to, however I was going to do it, I don't know, but my intent was always to cover whatever it was that I had took out of that account.
All right,
And
go ahead,
then, like I
Edna.
said, it just snowballed.
Go ahead, continue.
Okay, and like I was saying, that my actions, they resulted, it got out of control, and of course it was eventually found out what happened, and like I said, my actions have resulted in loss of my job. I cannot describe the regret and the embarrassment that I have for what I've done. So I went to a very dark place where I didn't even want it to exist anymore, but just talking it over with my family and friends, I'm able to get back on track again. And I just want to please ask that, the court, that Sheriff Thomas, the state of Robert Charles, just accept my apologies, and hopefully I'll be able to make the restitution to pay off what else is owed.
Thank you.
Yes, thank you for your time.
Ms. Smith, anything else?
Nothing to add at this time, Your Honor.
Ms. Tuttle for the state of Ohio?
Thank you, Your Honor. First, Patricia Schraff is present and would like to make a statement.
Okay, we can hear from Ms. Schrapp at this time. You can just stand right there. Spell your last name and state your name for the record here, then take your time and say what you want me to know.
Patricia J. Schraff, it's S-C-H-R-A-F-F as in Frank.
Thank you.
Judge, what I would like you to know, and the other members of our firm, is that Aretha was very well liked and very well regarded at our firm, and we were very much surprised by what happened. That being said, however, we are very concerned that this was an elderly person who was taken advantage of at an elder law firm, and that subsequent to Aretha's departure, she had tried to get, and actually was successful in getting a job at another probate elder law firm where something like this could happen again. I think needing assurances that this will never happen again to anybody else is very important. I've been in practice 45 years. I have never had anything like this happen. We're very disappointed in Aretha and very sad for her as well.
Thank you. Ms. Tuttle?
Thank you, Your Honor. The state is requesting that the defendant serve a prison term in this case. She used her position as a paralegal to gain access to these client funds. She violated the trust of her employer by forging their signature, and she violated her duty to the client. The firm, as Ms. Schraff said, really liked her. They really trusted her, and this really hurt their business, and it hurt the client. Ms. Fitzgerald wrote 8 separate checks to herself. She forged partner John Thomas's signature on each of those, and then cashed those checks in her personal bank account. It wasn't a mistaken transfer. It wasn't an error. It was a calculated process. She wrote herself $62,900 in checks from money that belonged to Madeline Wilby and used that to live her own life. From March to June, the defendant was spending over $20,000 a month from her own bank account. She was shopping at luxury stores such as Louis Vuitton and Coach, spending hundreds of dollars at Morton's Steakhouse. She was getting regular massages, buying tickets to the Las Vegas Raiders, spending hundreds of dollars on merchandise at the Cavs team store. She was using this money to live her life in a way that she wanted. The conduct is inexcusable. And that is why the state is requesting a prison term to be served here. The defendant does have 2 prior convictions, those being for a misdemeanor assault in 1988 and a misdemeanor theft and falsification in 1994. We're also requesting restitution in the amount of $1,000 to be paid to Schraff Thomas Law Firm. All other monetary loss was handled by their insurance carrier. Additionally, there is a civil judgment in effect through Judge Ruppel's court for 3 times the amount of the loss, as the defendant did not appear for her default judgment hearing. Thank you.
Thank you. Excuse me. This court reviewed the pre-sentence report and investigation and considered the victim impact statements that were received. To consider the facts and circumstances of this offense, the nature of the offense, and the defendant's conduct. And consider what's been said here today in court by the defendant herself, her lawyer, the prosecutor. Victim impact statement made here in court. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12. Factors indicating the conduct is more or less serious. In regards to being more serious, the court finds that the defendant used her position of trust in this law firm to facilitate the commission of this offense. The victim suffered serious economic harm, and the victim being was the estate of an 80-year-old woman, the injury exacerbated due to the age of the victim. These are all factors indicating, plus, quite frankly, just the criminal intent involved here. This wasn't just a one-time isolated incident where she stole something. This was occurred over a lengthy period of time, over multiple occasions, so it was well thought out, well planned. Every time that you did this was a separate offense, quite frankly. So the criminal intent is something that was ongoing and lasting for a substantial period of time, which is different from any thefts that we have, where it's just go in, you take something, or take something for some person. It's a one-time incident. Nothing makes this less serious. As for recidivism factors, the court does note that the defendant has 2 prior misdemeanor convictions, albeit it's that's right, 30 years ago, I think. Substantial time ago. Defendant certainly, at the probation department at least, minimized her conduct here, made it seem like she had to cover up some error that she committed. So she was writing checks to herself to do that. It just made no sense, her story. Now, she cleared it up here a little bit today, acknowledging that the first time she did it, that was the case, and then I can only presume she realized it was easy to do and decided to start doing it herself to the tune of $69,000, $64,000?
$62,900.
$62,900. Using the money to just live a lavish lifestyle. Factors indicating recidivism is less likely. The court finds the defendant has led a law-abiding life for a significant number of years. Again, he shares the 2 prior misdemeanor convictions, but the last was 30 years ago. So in the past 30 years, there's been nothing. Count 1 is a felony of the 3rd degree, which does not carry any presumptions either way for prison or community control sanctions. You can easily find here that prison is consistent with the purposes and principles of sentencing based on the nature of the conduct and the amount of money involved. And we'll find at this time the defendant, however, is amenable to community control sanctions. I'm going to put the defendant on community control sanctions for a period of 2 years. There are going to be consequences, however. You're going to serve 150 days in the Lake County Jail. You have credit for 1 day you've served. Further conditions, you are not to be employed by any law firm or any lawyer at all during your period of probation, at least. You're to obtain and maintain full-time employment, but that, again, should not be for a law firm or a lawyer or any legal practice. Not to use any drugs or alcohol. Urine screens have to be negative. perform 100 hours of community service, pay your court costs and supervision fees, pay restitution to the Sheriff Thomas Law Firm in the amount of $1,000. Not to make contact with the law firm, Sheriff Thomas Law Firm. If I find out you're doing any legal work, once you're done serving the jail sentence, you're going to get violated and go to prison. You understand that?
Yes, Your Honor.
So I said no employment by a law firm or lawyer, and I don't want you searching for some type of loophole in what I said. You're not to do any legal work. All right?
Yes, Your Honor.
Mr. Clement, anything else I should be thinking about for probation?
No, Your Honor, thank you.
You understand all the conditions of your community control sanctions?
Yes, Your Honor.
Any questions for me?
No, Your Honor.
I need to advise you if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, or if you commit another offense while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. And if I did that, it would be 36 months on count 1, additional 12 months on count 2, consecutive, so 48 months in prison, which would be served consecutive to any other sentence you may be serving at that time, or could get imposed if some new offense was committed. And that covers everything. Ms. Pell, is there anything else that I omitted or we should address?
No, Your Honor.
Ms. Smith,
Not on behalf of Ms. Fitzgerald, Your
thank
Honor.
you. We have President Case 24 CR 493. This case is captioned State of Ohio versus Kenneth Weber. Defendant was previously placed on community control sanctions to this court. Motion to terminate community control sanctions.
He was speaking, and
All
I
right,
was
go
just...
ahead. You can talk real quick. If you want.
I forgot to tell you, he wanted me to tell you that she wanted to say something on my behalf. That's all.
Okay, no problem. Thank you, Your Honor. Sorry.
All right, again, the defendant was previously placed on community control sanctions to this court. A motion to terminate community control sanctions was previously filed, and the defendant waived probable cause. In regards to that motion, subsequently, another motion to terminate community control sanctions was filed at the beginning of this week, alleging a new violation. In which the defendant has not waived probable cause on that. So we're scheduled for a final hearing on the first probation violation. Well, there's a probation violation and an addendum in regards to the first one, which probable cause is waived down. So we're here for a final hearing on that, and then for a probable cause and final hearing on the new probation violation. Defendant's here in court with counsel Mr. James Matthews. So Mr. Matthews, what's the defendant's intention at this time?
Thank you, Your Honor. Mr. Weber would like to waive the probable cause and final hearing on the new violation and the final hearing on the original violation, Your Honor.
Mr. Weber, you have been charged with violating the conditions of your community control sanctions. Specifically, it's alleged you first violated Rule 8. Rule 8 prohibits you from using, possessing, or having under your control any controlled substance not prescribed to you by a licensed physician. It's alleged that on February 6th, you submitted a urine screen that tested positive for amphetamines and marijuana. Also tested positive for methamphetamine. Subsequently, a week later, on February 13th, you submitted another urine screen, which is the basis for the second Rule 8 violation. And that day, again, tested positive for amphetamines, MDMA, and methamphetamine. Lastly, there's allegations you violated Rule 11, which requires you to comply with all special conditions set forth by this court. You were specifically instructed not to have any contact with the victim, in this case, Samantha Berry. And it's alleged that between March 1st and March 2nd, 2025, you had contact with the victim multiple times via the jail's messaging system. Now, you have the right to have, first of all, this last one, a probable cause hearing, which is a hearing where the state would be required to present some evidence that suggests you probably committed this violation. Then in regards to all three violations, you have the right to have a final hearing where the state would have to prove the actual merits of what they're alleging. Now, you could have either or both of these hearings, or you can waive the hearings and plead guilty to the violations. Your attorney has indicated he believes you want to waive the hearings and plead guilty. Is that correct?
Yes.
Well, before I can accept your waiver of the hearings, your admission, I need to make sure you understand the potential penalties you face if you are found to have in fact violated your community control sanctions. If in fact that did occur, the court could extend your probation up to a total of 5 years. It was originally 2.5 years, so I could extend it another 30 months. I could impose more restrictive sanctions against you, including an order that you serve more time in jail, or I could terminate your probation and send you to prison. If I did that, it could be 6 to 18 months on count 1, 6 to 18 months on count 2. I can order that those terms be served consecutively, so up to possibly 36 months in prison. You have credit for 291 days. You understand the potential consequences you face if you're found to have violated your community control sanctions?
I do.
Well, having been so advised, what do you want to do at this time? Do you want to have any of these hearings, or do you want to waive the hearings and admit to the violations?
I want to say guilty.
Very well, then, regarding the first Rule 8 violation for regards to when you submitted your urine sample on February 6th and for using marijuana and methamphetamine, what is your plea to that?
Guilty.
For the second violation in regards to the urine screen you submitted on February 13th, which tested positive for amphetamine, methamphetamine, and MDMA, what is your plea to that?
Guilty.
And for the third violation for violating Rule 11 by having contact with the victim in this matter, Samantha Berry, what is your plea to that?
Guilty.
The court will accept your pleas of guilty, find that you violated your community control sanctions. Mr. Matthews, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, thank you. Your Honor, Mr. Weber does understand that it is unlikely the court will consider continuing him on community control at this point. He would just ask the court to consider that he has spent 291 days between NeoCap and Lake County Jail, and that the hope would be that any sentence would be a concurrent sentence between the counts that he pled guilty to, Your Honor. Thank you. And there's also a person who would like to address the court.
Well, if there's anyone here who wants to speak on behalf of Mr. Weber, they can do so now. State your full name, please.
My name is Emily Smith.
Okay, go ahead
Am I
and
able
say.
to read this to
You can say whatever you'd like to say.
Thank you. Kenneth is my boyfriend. I'm beyond sad and disappointed to be here today. Kenneth is very intelligent and he's a caring man. He really cares about his children. He's a severe mental problem and he suffers trauma. This has led him to use drugs to cope with this problem. NeoCap honestly benefited Kenneth in a lot of ways that you might not see on paper, but I saw being in a relationship with him this entire time. He needs additional treatment and tools to live a sober, healthy, productive life, and I know Kenneth also must want to change and take accountability for his actions. I fear that without the opportunity for help, Kenneth will continue to struggle with sobriety and his mental health. I fear a long sentence will keep him in this vicious cycle. I fear that without intervention, Kenneth may not be with us in the future. I pray with this sentence today, it makes him realize the value of his life and how this affects the people who love him. Thank you.
Thank you, Ms. Smith. Mr. Weber, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yeah. I'm not gonna try to make any excuses for anything. You know, I put myself here. I did this, but I feel like circumstances matter. I would hope, and I didn't take anything to party or anything like that. I know more than ever. I have some stuff that's wrong with me mentally, and I've taken Adderall in the past before to cope with things that like even me out. It helps me concentrate, and what I thought I was taking was Adderall, and I didn't know it was meth, and I didn't even know what amphetamines was. I guess I took some.
Are you prescribed Adderall?
No, that's where I'm taking. I did know I took something that wasn't prescribed to me, so that's why I'm not trying to make excuses. But I just feel like circumstances matter. I didn't know what it was. So,
methamphetamine, MDMA. And you're claiming you didn't know that. You thought you were taking Adderall.
I did. And as far as contacting the mother of my kids, I wanted a way to be able to reach out to my daughter. I talked to my mother, and she said if I reached out, she gave me an email, and she said if I reached out, then I would have a way to contact her. So I sent the request, she accepted it, and then I got a message from her mother. I didn't even respond to the message until my mother told me that she said that she wanted to talk to me, and then we just started messaging back and forth from there. So I knew I was doing something I wasn't supposed to do, in a way, but I didn't think I would get.
What do you mean in a way? I specifically said no contact with her.
I understand, but
through court orders.
But
and in regards to the kids, I specifically even said it's got to be through court orders.
Okay. Well,
I did. I mean,
you did, but I just didn't know I could get in trouble. Well, I don't really understand these things. I didn't know I can get in trouble for her for her responding to sending me a message and me responding. I'm thinking I have to be trying to talk to her with her being unwilling to talk to me. I mean, I don't know. But these are the facts, and I did it. So I'm at the very least, I'm just asking that I can get some sort of leniency. I feel like for the first time in a long time, I want to face my problems instead of just running from them. And I know you feel like I went against exactly what you said. But sending me to prison, I feel like is easy. Is the easy way. I'll sit around. I'll do some time. I'll go home. But me continuing on probation and submitting to weekly drug tests, and me getting that mental health evaluation and finding out what's wrong with me and getting help, and I feel like that is hard. That's hard. And that's me facing my problems, and that's what I want to do. I don't want to just sit around and waste more of my life in jail or in prison. I want to get some help, and I want to stop going through this. I honestly really do. I'm tired of it. I turned 38 in jail. I'm getting older. I got kids, and I just want to get some help finally. That's all.
So was the marijuana was also inside the Adderall?
No.
Well, how'd that get in your system?
I drank an infused drink.
What do you mean you were drinking a fused drink?
They have drinks that are like, they sell them in smoke shops and sometimes like liquor stores and stuff, and they're infused with marijuana.
Will our equipment even test positive for one of those drinks?
If there's THC in it, yeah.
Well, when you were here for the sentencing, you were on the verge of going to prison then based on your history. But I gave you a chance, and and first of all, you adamantly denied having any drug issues when you were here for the sentencing, claimed no drug issues at all. Now you're testing positive for MDMA and methamphetamine and marijuana. I also was explicitly clear that if you had any contact at all with this victim due to the nature of this offense, you were getting the maximum sentence. I made that clear. Spelled it out. This case was one of the worst menacing cases I've ever dealt with in terms of what you did to get these charges. But I gave you a chance, and you were out of custody for, I don't know, a month maybe? Got out December 27th, and this happens first week of February. So you didn't even get a chance. The problem here is that you want to do what you want to do, and you're going to do whatever you want to do. It doesn't matter what I say, doesn't matter what the probation officer says. Kenneth Weber is going to do what Kenneth Weber wants to do, how he wants to do it, and screw everybody else for telling me to do something different. But I gave you that break, despite your record. You got a horrible record. You've been to prison before. For multiple cases, for similar type of conduct. have convictions for similar type of conduct. But I put you on probation, gave you a chance. And within a little over a month, you're in violation. A little over a month after getting out and being on your own, you're in violation. So again, it's clear you're going to do what you want to do. Prison's consistent with the purposes and principles of sentencing. The defendant's not amenable to community control sanctions. He's made that clear. Therefore, it's a sentence of this court that on counts 1 and 2, defendant served a term in prison of 18 months. Those are to be served consecutive to each other for a term of 36 months in prison. If credit for 291 days you've already served, I need to advise you upon your release from prison, you could be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Court further finds consecutive service is necessary to protect the public from future crime and to punish the offender. It's not disproportionate to the seriousness of his conduct and to the danger he poses to the public. And his history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by the offender. And at least 2 of these offenses committed as a part of one or more courses of conduct, and the harm caused by these multiple offenses is so great or unusual that no single prison term for any one of the offenses committed as a part of the course of conduct adequately reflects the seriousness of this conduct. Mr. Matthews, is there anything else for the record?
No, Your Honor. Thank you.